Constitutional attorney Seth Berenzweig. Seth, good to see you. First off, what will you be watching for today and the rest of this week? Because we are expecting a verdict as soon as this week.
Well, this is defamation trial 2.0. Mr. Trump already incurred a $5 million verdict in the first case, and here we go again. Ms. Carroll is seeking $10 million, and what I'm expecting to see today is a difficult choice by defense counsel. Will Mr. Trump, in fact, testify? I think it's about a 50-50 shot. There's a lot that he would like to say, but there's not much that he is allowed to say. The judge has issued a ruling which has really greatly narrowed the scope of his testimony in the case, and he could testify with respect to the question of state of mind. As was noted a moment ago in your report, part of the defamation verdict will involve punitive damages, and the state of mind with regard to presence or absence of malice is going to be relevant. In a traditional trial where damages are frankly hard to calculate at very high levels, this of course is not your normal defamation trial. There would be a testimony with regard to the absence of malice. However, if he does take the stand, one of the things that I would also expect to occur is that trial counsel for the plaintiff will really have kind of a field day. One of the questions that I would bet would come up would be his wealth. And the ability to pay is something that is typically admitted as evidence in defamation trials. He is a self-professed billionaire, so they would say, Mr. Trump, is $10 million is really just kind of a rounding error for you, isn't that right? So it'll be very interesting to see what happens over the next day.
It seems like, especially in such a civil trial, there's going to be a lot of discretion, and correct me if I'm wrong, left to the jury, like his word against her word, basically, especially if Trump takes the stand. I mean, if you say he's going to be talking about his state of mind, then the jury will just have to consider, well, do they believe him over E. Jean Carroll, right?
Well, that's exactly right. And one of the typical jury instructions in litigation is an instruction as to weighing credibility, which is absolutely within their purview. However, when you hear these out-of-court statements, which are admissible, and you also hear these deposition excerpts, which is a typical maneuver in trial, in this kind of litigation at trial, they'll be able to weigh that in too. And I think that when you put it all together, it's going to be a stretch for the defense to say that he didn't really have any malintent. Of course, as you correctly note, it's in their discretion. It's entirely up to the jury. It will largely be a weight upon an issue of credibility, and that will be a jury instruction. I would expect that the verdict and this entire case will wrap up at the latest by this Friday.
Okay. So how much do you think Trump's words, I guess, will backfire on him, especially with, Carroll's lawyers saying that they're going to submit the things that he said outside the courtroom, which he cannot say on the stand, as a part of the evidence?
Yeah, it kind of reminds me of those old cartoons where somebody throws something up in the air and then it just kind of circles back to hit them in the head. This is really something that, unfortunately for Mr. Trump, is going to be a recurring problem. These are statements that will come back. They will come in the record. This is something that the plaintiff's counsel, as a matter of evidence, will absolutely have the ability to admit. There will really be no objection that can be posited by the defendant, because it really goes not only to the continued damages with respect to reputation, but also, as we've noted, with respect to intent. Also keep in mind that the plaintiff she's done a really good job on her case. She had a damages expert from Northwestern University testify at the trial at the end of last week, substantiating alleged damages in excess of $10 million. So on the one hand, there's tremendous pressure for Mr. Trump to testify, and you know that he wants to do it, but the problem is that the scope of his testimony has been greatly narrowed. So I say it's at best a 50-50 shot that they actually put him on the stand.
Yeah, it could. I mean, of course, not knowing, if he will actually stay within those restrictions that have been ruled by the judge. Right. Lastly, that Trump's team has asked for a mistrial. What's the basis for that?
Well, the basis for the mistrial motion, which was really kind of dead on arrival, is the allegation that when there were allegations by the plaintiff that there were these terrible malicious attacks online through, for example, social media, and that forms a part of her damages, that she should have preserved that evidence. It's a claim that the legal beagles call spoliation, which talks about the need to preserve evidence. So it was a creative attempt. It was not likely to win, and it was rejected by the judge. It was based upon the claim that they should have preserved the evidence, but quite frankly, I think the expert really tied that up in a ribbon and a bow. So since that has failed, we know that we will be heading towards a jury verdict within the next couple of days.
Seth Berenzweig, a pleasure to have you on. Thank you very much.
My pleasure.